Hello everyone, Mr. Lipchick here, and this segment of instruction will be on criminal law. Criminal law. A crime is an act that breaks a criminal law and causes injury or harm to people or society in general. It can involve inaction, such as if a teacher fails to report child abuse. The criminal justice system is the system of state and federal courts, judges, lawyers, and police and prisons responsible for enforcing criminal law. There is a separate juvenile justice system for offenders who are under the age of 18. Types of crimes. Petty offenses are minor crimes such as speeding, disturbing the peace, and littering. Punishment usually involves a fine or citation rather than an arrest. Misdemeanors are more serious crimes for which a person can be sentenced up to a year or less in jail. Vandalism, simple assault, and passing bad checks are examples of misdemeanors. Felonies are crimes for which a person can spend a year or more in jail. In cases of murder, the punishment can be as high as death in some cases. Crimes such as rape, murder, arson, kidnapping, and fraud are listed under felonies. And persons convicted of felonies are called felons and can be denied certain civil rights such as voting and owning firearms. Felons can be barred from certain professions such as education or law. There are steps in criminal cases. A criminal case begins with a police investigation and an arrest for the offense. A valid warrant is required unless the police witness the crime being committed. The person is taken to the police station and booked into the police criminal records. After the arrest, the subject must be brought before a judge as quickly as possible, usually within 24 hours, and charged with a crime. The judge explains the charges and reads the defendant his or her rights. In misdemeanor cases, the defendant may plead guilty and the judge can decide on a penalty right there. If the defendant pleads not guilty, a trial date is set. The judge can release the defendant until trial, hold them over, or require bail according to the severity of the crime. A preliminary hearing or grand jury will take place depending on the state in which it is occurring or if it is a federal trial. If a grand jury hears the case, they will decide if there is enough evidence to hand up an indictment or formal criminal charge. If a preliminary hearing is used, both sides present evidence of guilt or innocence, and the judge decides if there is enough evidence for the case to go to trial. In misdemeanor cases, courts use information or sworn statement from the prosecution indicating that there is enough evidence to go to trial. In most criminal cases, prosecution and defense work out a plea bargain in which the defendant pleads guilty to a lesser crime or fewer crimes. A murder defendant, for instance, may plead guilty to manslaughter and receive a more lenient sentence. It is an efficient way to process cases, especially when the prosecution's case is weak. After a defendant is indicted, or a judge has ordered the case to go to trial, the defendant is arraigned. The defendant is formally charged and asked to enter a plea of guilty or not guilty. The defendant may plead not guilty by reason of insanity, or guilty, or no contest, but only in some states. In a no contest plea, the defendant does not admit guilt but gives up the right to a defense. To the right, you see a picture of Jared Lochner, in the gunman in the Arizona shootings, who tried to plead an insanity defense, but the judge would not allow the plea. So the judge, if you're going to plead insanity, there are court-appointed psychiatrists that will examine you, and the judge will determine whether or not that is a permissible plea. Next, the defendant goes to trial. The defendant is entitled to a jury of his or her peers. The defendant can waive a jury trial and have the case heard by a judge. Or the defendant does not have to testify. They're presumed innocent, and they have the right against self-incrimination. After the trial, the jury will deliberate and make a decision on the case. They must find the defendant guilty beyond a reasonable doubt if they are to convict. So if there is reasonable doubt that the defendant may not have done it, they must acquit the defendant. A hung jury may result if no unanimous verdict can be reached. And in cases of a hung jury, the prosecution usually has the opportunity to try the case again, and sometimes even a third time. If the defendant is found guilty, the judge may hold a separate hearing to decide the sentence. The background and mental health of the individual might influence decisions for sentencing. That concludes our discussion on criminal law. Thank you for attending, and I look forward to seeing you in the live lesson. Have a great day.